Sure.
All right, Dennis. Feel free to get it going.
Good to go.
All right, gentlemen. I'll just jump on in with the business at hand. Thank you guys for taking time out of your busy schedules to join us so that we can go ahead and meet some of these metric deadlines. And also just while we're here for the legal report, we'll go ahead and do a couple application reviews if that's okay with y'all.
Yeah. I have a question. Do we not need to call it to order and go through the normal thing to declare this an actual meeting with an adequate amount to make votes?
Okay.
Seems like we ought to declare ourselves officially open for business and have a quorum.
Yeah, I agree that we should. So with that, this is Bart Howard, the chairman, and I will call the telephone conference meeting to order. And if we could read our name and notify the fact that we are present at the meeting.
That sounds perfect. Thank you, Chairman. I'll go ahead and take roll, and then we'll read the notice of meeting and then the statement of necessity as well. First of all, we'll just go ahead and take roll. We have Bart Howard.
Present.
Steve Harp.
Present.
Josh Holden. Chip Hellman.
Present.
And then Angela Hoover. Looks like we have quorum, Chairman. If I may, I'll go ahead and read the notice of meeting. The notice of January 8, 2018 meeting of the Collection Service Board meeting was posted to the Collection Service Board website on December 14th, 2017. Chairman, we have quorum. And as a reminder as well, before I read the statement of necessity, we'll have to, of course, do a roll call vote on each actionable item as well. And if we could, legal would prefer if we go ahead and do a roll call vote as well for the statement of necessity, that you're adopting this statement as your statement as well. So if you listen carefully to that, if it sounds okay with you, we'll take a roll call vote on the statement of necessity, which is necessary anytime we do a teleconference, and then we'll move on to the agenda. The statement of necessity reads as follows. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by the governing body at the meeting requiring timely action by the body. That physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regular scheduled meeting for the Tennessee Collection Service Board, and the purpose of today's meeting, with 3 members attending by teleconference, is to discuss the agenda as noticed on the website earlier. So that being said, do we have a motion to accept the statement of necessity?
So moved.
And if you
there's
make
a motion, there's a motion been made and seconded that we accept the what is it called, Glenn?
The statement of necessity. Now, who was the original motion?
Statement of necessity.
The original motion, who was that?
Chip.
All right, thank you, Chip.
Steve Harp second.
All right, perfect. And if I may, I'll have to do a roll call vote anytime we do a teleconference. So if I'll just go down and then we'll get ayes or nays. Bart Howard?
Aye.
Steve Harp?
Aye.
Chip Hellman?
Aye.
All right, thank you, gentlemen. We'll move on to the agenda as noticed earlier. Will that suffice? Does anyone have any amendments or edits that they'd like to make, or would someone like to make a motion to accept that as printed?
Chip Hellman will move to accept the agenda as printed.
Thank you, sir. Do we have a second?
Second.
Perfect.
Steve Harp.
Thanks, sir.
Good.
Now, let me call roll then. Bart Howard?
Mm-hmm. Yes. Aye.
Steve Harp?
Yes.
And Chip Hellman?
Yes.
All right, thank you, gentlemen. All right, we'll move on to the next item, which is the October minutes. Did everyone have an opportunity to look at that, or is there anything that you'd like to add or amend or anything with in regards to that? It's open for discussion, of course.
They're fine to me.
I move we approve the minutes.
Thank you, sir.
Chip Hellman.
Do we have a second?
Yes.
All right, thank you, sir. Do we I'll go ahead and do a roll call vote then to accept the October minutes We have Bart Howard,
Aye.
Steve Harb,
Aye.
and Chip Hellman.
Aye.
All right, thank you. So it's so approved then. Now for the legal report. Mr. Gregory or Ms. Thomas, would somebody like to take it from there? Legal
report, yes.
Yes, I believe Dennis is gonna take the lead on that. If there are any particular questions, if you could just let him know which number, and of course what your question is. If there are no questions, he'll go ahead and read the complaint numbers, and we can begin accepting the legal report.
Okay.
Steve Harb, number 26. Let me see. The respondent, we're basing this on what the complainant said, not the respondent saying. Do we have more information that they did in fact threaten the criminal prosecution? Is there a recording, or how do we know? Are we just taking the complainant's word for it and not taking the respondent's word that they don't threaten legal action? Is there more to know that they in fact did do wrong?
This is 26, and just to make sure I've got the right one, 2017-05-8881.
Yes.
Okay, give me just a second, it's just to look back over it. No, you're correct. We're taking the complainant's word that the at least the criminal portion, well, all of it, quite frankly. But if I think what may have happened is that the complainant confused civil warrant with a criminal action, which is actually in Tennessee at least, civil warrant can refer to a general sessions civil warrant, which is only a civil matter. So no, there is nothing that we possess currently without going back to the complainant in all likelihood to give us any more information about the threat of criminal prosecution.
Well, we have no disciplinary history with this particular group, and the license seems to be active. Now, I don't necessarily like the idea of taking the agency's answer over the debtor, but I don't want to place any more weight on the debtor's complaint, because sometimes complaints are made just because they're PO'd at the agency for calling them.
All right.
So I don't know. I don't know. Let's see. We were going to charge them $1,000. I mean, I'd like for some conversation from the other two gentlemen. I don't see enough basis or proof to know that what the allegation was is correct. It doesn't mean it didn't happen, but we don't know it did. So maybe a letter of warning as opposed to fining them. I mean, because if we have no other reason, Bart, what do you guys think?
I think that without do these complainants swear to their complaint when they send them? Is it under notarized, or is it a sworn complaint?
No, it's not sworn, but effectively what the online complaint form asked them for, do you agree with it, and is it true and accurate? But it doesn't actually place them under. I mean, obviously no one's there to place them under oath, but it doesn't. There's no affirmation or oath that they take.
Yeah. So
they could just be PO'd and
right.
Say, I didn't like being called, and I'm going to write something nasty. And I mean, not that everybody does that, because I know we have some folks who don't do right when they call. But how do we know?
Yeah.
You're right. At this point, we'd just be taking the complainant's version of the story, right?
Right.
Yeah, well, I want to be very careful to say that I don't lean towards the agency, but I see no reason to lean towards the complainant just because they made a complaint either. Yeah. You don't know.
I agree with you, Steve. I wonder if this agency has recordings of their
calls. Yeah, that's what I was wondering as well, because it seems to me that if I adamantly believed we don't ever do that, we don't make false threats, which is what this is, then it would be very easy for me to go back and listen to the calls on this account, just confirm that I didn't have a rogue collector. So, I mean, can we ask for those recordings, or do they need to attest to the fact that they went back and listened to the recordings? Surely they record calls.
Yeah, I agree. In this particular instance, they didn't attach as part of the response the recording. We could ask for it certainly, or again, this may be just an issue where the complainant maybe overblew the maybe not knowing what civil warrant really meant. I think the warrant had been making up part of the terminology may have frightened them and believed that it was criminal prosecution rather than just a lawsuit, civil lawsuit. So I certainly would have no issue. Not my call anyway, but it's well within the board's purview to recommend a letter of warning, and looking at the history, it doesn't appear that there's a involved history with this individual. Well, no history actually. So,
Rather than take more time, I'd be comfortable with a letter of warning, because, of course, that puts them on record that they've been warned, and if anything ever comes up again, you'll see a letter of warning. So, Mark, you've been doing this a lot longer than I have. What do you think?
Yeah, Steve, I'm glad you brought it up. It was on my list too. I don't know what we can get from the agency, unless like Chip suggested, a copy of the recording or transcript of the recordings that would or would not. It would be real nice if it would indicate that they said legal action and civil action, but as a debtor, they may not know the difference between legal action and civil action. They may just say legal action means criminal.
We can't fix that.
No.
I mean, we're not responsible for them knowing how to understand the call if they spoke correctly. We just can't let them threaten people improperly. So
that's true.
If you guys want to ask for a recording, I'm good with that. If you want to just give them a letter of warning, I'm good with that. I just felt the issue should be raised. I'd
like to get a copy of the recording, or at least a transcript of the recording that would, if nothing else, would show to the agency that we wouldn't put up with that if we had to.
I tell you, if the agency doesn't record, then I certainly would give them a letter of warning and warn them to start recording.
Yes.
But that's just my suggestion. Whatever you guys want to do.
I'd like to request a copy of the recording or a transcript of the recording, and just table it until we get that in.
Okay, I'm good with that. Chip, you good with that?
Yep, I'd second that if it needs a motion.
I just made a motion if we need one.
Okay. I think we don't need a motion on one particular matter. When we get to the end, we'll approve the legal report with additions, so that will take care of that.
And we've taken note of that as well. So we'll go ahead and see if we can get a copy of the recording or transcript.
Okay. Are there any other questions on the legal report?
I just have one more on number 32.
Okay.
Do we know that this is not an attorney that made the call?
I'm going back over it real quickly. I think this one I remember.
Because when you're dealing with a subrogation claim, agencies don't use the word subrogation claim that much, to my knowledge. Now, maybe they might out of their legal department or their legal. Can't call it a legal department out of the area that works with law. But so I guess I'm just curious if we had any knowledge if this was a law firm, because we can't really do anything with law
Right.
firms.
Yeah, no, and in fact, I remember using the term subrogation just to make sure that it was clear that it wasn't subrogation. No, it wasn't from an attorney.
Okay.
Definitely not.
I'm good.
Okay. Yeah, that's all right. Are there any others? If not, I'll accept a motion to approve the legal report as amended.
So moved.
So moved.
Steve Hart.
Seconded, Chip Hellman.
Okay. Glenn, if you'll read the roll.
Yes, sir. Bart Howard,
Aye.
Steve Hart,
Yes.
Chip Hellman.
Aye.
All right, it's so approved with those amendments or additions as so stated.
And gentlemen, you all were approving the one or two cases that were on the addendum.
Yes, sir.
Okay, great.
Yes, as amended would have been the motion.
And just for clarity of the record, I'm going to ask Dennis if you could read the complaint numbers, just so we know, just so we have a record of which cases were processed.
Okay. You want me to read the corresponding, like numerical, or just the case number itself? Just the number.
Yeah,
Okay.
just the numbers.
2017-04 9421. 2017-05 4041. 2017-04 2941. 2017-04 3001. 2017-04 3951. 2017-04 3681. 2017-04 7751. 2017-04 8181. 2017-05 4361. 2017-04 8561. 2017-05 1971. 2017-05 3051. 2017-05 3081. 2017-04 9211. 2017-05 4111. 2017-05 4131. 2017-05 4171. 2017-05 3931. 2017-05 4911. 2017-05 4771. 2017-05 5621. 2017-05 5921. 2017-05 7381. 2017-05 7451. 2017-05 8501. 2017-05 8881. 2017-05 9161. 2017-05 9451. 2017-05 9921. 2017-06 0131. 2017-06 0381. 2017-06 0441. 2017-06 0711. 2017-06 0751. 2017-06 1141. 2017-06 1291. 2016-07 5641. 2017-04 2381. 2017-07 7961. And that completes the legal report complaint numbers.
Thank you, Dennis.
Thank you. Application reviews. I don't have the agenda up. Is that the next on the agenda?
Yes, that's correct. Application reviews. There's should be two before you. Basically, this is their litigation disclosures, and administratively, we haven't been granted the option or the authority to approve applications if their financials check out, but there's litigation disclosure. So we typically, as you gentlemen know, we bring those before the board for review. So their financials are fine; they've passed the initial audit, but if there's anything there that the board would like to discuss in regards to those, now these are two different applications, so you've got 2 pages and 2 different applications. They're both initials, and there's no problems with their financials. So what we're looking at here is just the disclosures themselves.
Is this a renewal in each case?
They're initials.
Initial applications, and they have this many complaints? How have they been in Tennessee? Well, let's see. Do they have any suits in Tennessee? One of them doesn't tell us where. Well,
I don't think there's any of them in Tennessee, or at least.
No.
At least they don't indicate Tennessee.
So this is initial application in both cases?
Yes, sir. Mm-hmm. That's correct.
When I was in the agency business, and I know Steve and Chip can agree with me on this, there's a lot of lawsuits filed that are just trying to get $100 or $500 or $1,000 out of me, and depending on the size. Or $2,500, but and depending on the size of the agencies, how many of those are going to be active at any given time?
Yeah, I don't have a problem with them myself. If everything else is checked out, I move we approve these.
Okay.
Motion's been made. We approve.
I second.
Your second. And seconded.
I'd like to make a comment.
Yes, sir.
In the future, I'd request that they let us know the state the suits are in. I appreciate the fact that one guy told us what state they were in. We don't need to go back and ask. But if somebody was sued out of Tennessee on the second guy, that'd be awfully interesting because he's not collecting in the states yet. But other than that, if they checked out every other way and they're in this many states, they've got a pretty good legal department. They're not stupid.
Yes, sir.
They're not fly by night, so I'd be okay with it. It's just a comment.
Okay. Motion's on the table. Glenn, would you read the
yes, sir.
Roll call, please?
Bart Howard?
Got to approve a second. Motion moves second. You got to have a second. It meant second.
Did Mr. Harb, did you second it?
I just did, yes.
Okay, great. All right. Then if we could do a roll call then, because Chip gave us the original motion, I'll go down the roll call vote. Bart Howard?
Aye.
Chip Hellman?
Aye.
Steve Harb?
Aye.
Thank you, gentlemen. It's approved. And then this is really just there's no new business. This is really just an extension of the application reviews. Something that while we had everyone here, I felt it might be an opportunity, especially given the context, since we just had two application reviews, to discuss a way forward as an option. And it may be something that you may not be prepared to discuss today. You may want to bring it up at the next meeting in February. But really, the issue is that, it's right now we bring in anything with open litigation or litigation disclosures to the board, as you know, just like what we did with these. Now, going forward, if you want to do that way, that's fine. We can continue doing that. However, if the board wanted to grant administrative authority to approve or deny applications with open litigation where there's no evidence of moral turpitude, and by evidence meaning there's nothing beyond the disclosures, and there's nothing in Tennessee as Mr. Harb described. There's nothing that's maybe or evidence that's particular to moral turpitude in particular. And of course, there'd have to be some guidelines for what that would entail. We wouldn't just broadly describe that and then loop that in. Or here's the other option. We could send all applications with open litigation, just like these two, immediately to two members of the board. And like what we've done with other boards, those two members will decide whether or not they're fine with that, and then they just approve it on the record. So that's something for administratively going forward. If somebody wants to discuss, then that's one option, just to kind of speed these along so they're not waiting. That's one way to do that. It's not waiting for on board meetings, but that's up to you gentlemen to discuss and to decide. But those are a couple options that we've done with other boards or that we've used before. So that's all for your.
I don't think it's fair that we force an agency to wait for a license because of something that they can't prove or disprove anyway. At least they're honest enough to tell us about it. We would know about it if they didn't tell us. So,
Right.
I personally think administratively you could do it. I would like to see, like Steve said, any Tennessee lawsuits.
Right.
I'd like to see those, particularly on agencies that are first time. They're not current agencies. They're not renewals.
So you would say maybe all initial applications with litigation disclosures in Tennessee, you would like to see those that where there's no evidence of moral turpitude. You would like to see those, and then the rest of them, though, you would be okay if administratively if those were approved, if their financials, of course, were to line up. Is that your position?
That would be mine, but I'm not.
Right.
I'm not the board. I'm just.
Of
That
course.
would be my
Can I
own opinion.
suggest something to that? I mean, that's a good idea, but we need to have a requirement that they disclose the state the litigation's in. Currently,
Sure.
only one of them discloses. That's not a requirement, so we amend our application to say, in what state is the litigation in? And as Bart pointed out, if they're in litigation and it's an initial application and litigation in Tennessee, well, that's moral turpitude for us.
Right.
But
Right.
If, but we should add that they have to disclose the state, because it doesn't appear that they have to disclose the state. The second guy didn't, first guy did. And
Okay.
the first guy also disclosed it was the nature of the suit, FDCPA. The second guy didn't disclose the nature of the suit. I like the first guy's response. State, nature. If they tell us it's not in Tennessee and it's an FDCPA suit, I'm good with that. But if they tell us it's in Tennessee or if it's some other kind of suit, that may bear another level of scrutiny, which you might do something like let 3 board members, because that's a quorum, look at it. I mean, that's maybe one step too far, but I would like to add the requirement that they tell us the state and the basis of the case.
Gotcha. Okay. That sounds good. If you like, then we'll just bring it up to discussion at the next board meeting since it's just around the corner anyway, and then we'll have maybe some options for you.
That's good. That's a great idea. Different options we can vote on then.
All right. Anything else, gentlemen, before someone moves to adjourn?
I have nothing.
Chip moves to adjourn.
All right.
Steve Hart, second.
And seconded. All in favor?
Aye.
I got to call a roll.
All right.
Okay.
Well, I'll just run down the roll then. Bart Howard,
Aye.
Steve Hart,
Aye.
Chip Hellman.
Aye.
Thank you, gentlemen. I really do appreciate your time. It's very.
Thank you all. Thanks. Good work.
Yep. Thank you.
Excellent legal report, by the way. Thank
Yeah. Very good.
you. Bye-bye.
Y'all take
Thanks,
care.
bye.
Thank you.
I was getting ready for a disc to pop out here.